Okay, so I'm going to start the seminar now, and what I'm going to do, I'm going to experiment this time. I'm going to allow people to ask questions as they go along, so I'm going to unmute you all in a moment, and hopefully we don't get Zoom bombed, and we'll try that. And also, you can also write questions, and I'll try to answer that as I go along. So take me a moment here to unmute everybody. I think there's a unmute all button, but I can't find it right now. And okay, so ask questions as I go. Now I'm hearing a little feedback from myself here. I'm not sure why. So hopefully that won't happen too often. If anyone has a problem with that, they can unmute their. I guess they can unmute their phones on their own. Okay, so, and then you can always ask questions. So I'm going to start proceeding. My name again is Mike Solomon with the law firm of Solomon, Steiner & Peck. And our firm's been around since 1993, since a long time. I've been around a lot longer than that. And my background, I worked at the IRS at the beginning of my career. I have a master's in tax law, and I've been representing business owners in their estate planning, their general business matters for literally decades. So that's my background. And our firm also does a lot of estate planning in other areas of law, real estate and elder law. So we have a vast different areas that we can handle. So that's a little background on the firm. So what I'm going to do is go along on the outline that you should all have on your screen, talk about estate and succession planning for the business owner. And I'm going to start with the beginning of the outline. You'll see there. Again, if you have questions and want to send them to me or ask them over the phone here, I'll be glad to try to do that. So let me first talk about estate taxes, because everyone is always interested in that. Right now, the federal exemption per person from the federal estate tax is $11,580,000 a person. So a married couple is over $23 million. That is set to expire beginning 2026. And unless Congress does something, it will expire and revert to the old law. The old law, the exemption back then in 2016, was on the order of a little over $5 million, but it's adjusted for inflation, just as this exemption is adjusted for inflation. So if the law expires, I've estimated, assuming a 2% inflation rate, that the exemption will be somewhere between $6.5 million to $7 million a person. Still a large number, and for most people, that'll be more than sufficient, but you never know. Now, then the other thing is that the existing number, 11,580,000, is also adjusted for inflation. And next year, the number goes up to 11,700,000. So we have a vast area to work with without worrying about federal estate taxes for most people. There is no Ohio estate tax anymore. That was eliminated almost a decade ago. And there's no Ohio gift tax. The federal gift tax only kicks in if you give away more than $11,580,000. So there's really no effective gift tax either at the federal level. So those are the basic death tax rules. The other important rule to know is the inherited asset step up and basis rules. And income tax planning has become more and more an important part of federal estate planning than it used to be. It used to be people always focused on the federal estate tax. Now they're starting to look more and more at the income tax consequences in estate planning. So the step up and basis rules work this way. And let's say you bought Google stock for $1 and it grew to $1,000 and you sold the Google stock. Your gain would be almost $1,000. You pay capital gains tax on it. If you give away the Google stock to your children, let's say, and they sell the Google stock, they still pay the same capital gains. But if you die holding the Google stock, all the capital gains are wiped out. It steps up to the basis that the basis in the stock becomes the date of death value. So if they inherit the $1,000 stock from you, then they sell it, there'd be no income taxes to pay. So that's the overview of the death taxes and income taxes in estate planning. So now, what I'm going to do is use a scenario, and then we'll talk about different issues and how to solve them. So you have Tom and Pam. They have 2 children in the family business, 1 child not in the business. The 2 children in the business have different capabilities of managing the business. All the children are married, they have some grandchildren, and they want to pass this business on to their children and possibly their grandchildren. But at the same time, they need money to live on, to keep their lifestyle. So that's this general scenario. So now the next question is, what do we do from there? So now there are whole sorts of issues that you have to think about. Fairness. I always have clients talk about, how can I make this fair? Is it possible to make it fair? And I'm going to talk about all this. Lifetime issues of control. Who controls the business while you're alive? Should you give the shares to your children, even adult children, while you're alive, or do you wait till you're passing? What's the impact on their legal rights once they become a shareholder? What happens to shares owned by parents and you're passing? You're being the parents. What happens if your children inherit the shares and they inherit them and they get a divorce? What happens if a child is in the business and they become disabled? What do you do in those situations? How can the business provide for you when you retire if you've transferred to your children? And what happens if your children just don't want to own the business? So those are all sorts of different questions that arise when you do estate planning for business owners, mostly called succession planning. So the next question is what are the problems and what are the solutions? We've discussed some of the problems. So what happens when one or both parents pass away? And you have basically three options. I only put two on the board and I'll discuss the third. Option number one is the shares are purchased back by the company or by the other children. So remember that income tax step up and basis rule I talked about. So let's say you started your business way back when, you put in $10,000, your business is worth $1 million right now. If you sell your business, then you're going to pay that capital gains. If you die holding those shares, then I'm going to use a husband and wife where the husband dies first in my example. Husband dies first. Let's say all the shares are bought back by the children or by the company. There's no income tax due to the surviving spouse. He or she gets that money free of income taxes and free of estate taxes. By the way, no matter how valuable the business is, if it all goes to the surviving spouse, it could be worth $50 million, and there's no federal estate tax at that point in time. There will be later when the surviving spouse dies, but there's no estate tax then, and there's no income tax due. So that's a good tax solution. If life insurance is used to fund the buyout, many times it is, because who has millions of dollars of cash lying around, especially in a family business? So many times, if you've done the planning enough in advance, there'll be life insurance on the owner's lives, the husband and wife in my example, or one of them. So when the husband dies in my example, if there's a life insurance policy on the husband, and the policy is either owned by the spouse or by the children or by the company, that money is used to buy the shares so the surviving spouse has liquidity. And if you have enough life insurance, that solves the whole problem. If you don't, many times what we have, to the extent the price is above what the amount of life insurance, you use an installment note. So the business pays for itself over a period of years. Many times, typically I use around a 10-year payout, sometimes 15, it can be longer. Very rarely do I use a shorter one because you don't want to put the business in a cash flow crunch. So those are the parameters. That's one option. So you just fund it with life insurance and an installment note, have the shares bought on the death of the first spouse. The surviving spouse has all that money to live off of. Option two, if you don't need the money, maybe the surviving spouse doesn't need the money, or there's just one spouse alive, you bequeath the shares to the children. And they just inherit the shares. And no money has to change hands. The third option, which I didn't put down here, is maybe both the husband and wife are heavily involved in the business. Husband dies and wife wants to still control the business. She inherits the business and she just continues to earn money that way. So those are the three basic options when one or both of the parents pass away. Before I go on, anyone have any questions on that? Okay, so I'm going to go on to the next page. So what happens? Did I go too far? Okay, so let's say now the child inherits the business, either gets some of the business or inherits it during life. Excuse me, inherits it after the parent passes away. And then the child quits. Well, usually you have a buyout formula. You have some sort of formula that says, look, I don't want this child who's no longer in the business to still be a shareholder. There's two reasons. Number one, the child in the business gets no benefits from owning shares unless dividends are paid. And the remaining child or children in the business may not want to pay out dividends. They may want to plow the money back in the business, continue to grow it, buy inventory, et cetera. So they have two different interests. So the child not in the business probably wants to be cashed out. Now, the problem is there's probably not that much cash available to buy that child out. So at that point, typically, we have that when the child quits or is fired, whatever, they're bought out with an installment note again. So the business funds the buyout of the child over a long period of time. The next question is, what if the child owns shares and becomes divorced? What you don't want to have happen is half of those shares to end up with the daughter-in-law or son-in-law. It's a devastating thing. So typically, you have a shareholders agreement that prohibits anyone but a family member from owning any shares of the company. Now, whether that's enforceable, I think it is. The divorce courts sometimes, domestic relations courts sometimes do things that on their own, notwithstanding the agreement, but you definitely want a shareholders agreement that says they can't own shares if they're not of the blood of the family. And then you have buyout terms also. So in case for some reason it is a forced buyout, you at least have an installment note option. Next question, what if the child in the business, and this is while mom and dad are alive or after mom and dad pass away, what if a child dies or becomes disabled? So if you already have a business, you have your children involved in the business, you already have disability insurance for your children, whether you know it or not. The disability insurance is your moral obligation to make sure your child is not destitute. So if you're running a business right now and you have your children in the business, if they become disabled, you're not just going to tell them, well, you're out of luck. See you later. Get Social Security disability. See you later. They're not going to survive on that. So in all probability, you're going to feel some sort of obligation to continue their salary. And that causes problems, especially if other children are in the business. Why is Johnny getting a salary? He can't work anymore. I'm working to support you, mom and dad, and Johnny, and also myself. That's not fair. So I recommend you give serious consideration if you're bringing your kids in the business, consider getting them disability insurance, even before they own shares. That way, if something bad happens to them, you don't feel this obligation that you've got to fund their salary for the rest of your life. But if they do own shares, again, you want to have a provision in what's called a shareholders agreement. Some people call it a buyout agreement that says on disability, we buy Johnny out with an installment note. So that's what I recommend, how to address that issue. Now, the big one, I have all the time. So you've got some kids in the business, some not in the business. Mom and dad have built up a nice estate. A good portion of it, many times almost all of it, is based upon the family business. And so they say, how do I make it fair? How do I make this fair for everybody? And the shorthand answer, you can't make it fair, because it's never going to be perfect when you're dealing with a privately held business. Do you give all the children equal ownership in the privately held business, even the ones who aren't in the business? Is that fair to the children who may have worked 10, 20, 30 years with you to help build up the business so that their sibling who's not involved in the business shares in all of that? That may not be fair. Or do you cut the child out who's not in the business? Well, there may be nothing else for them to inherit. So, they're what I call rough justice. You can't be perfect on this. You're going to drive yourself crazy trying to make it equal. So what I recommend is you use a rough justice approach, a variety of choices. You can say, that the child inherits less of the estate, but the children in the business inherit less of your other assets. So the child not in the business inherits more of your other assets. You try to make it fairer. You could have them inherit the same amount. In other words, the children in the business inherit the business, and they also get, let's say there are 3 children. They get the entire business, the 2 in the business inherit the entire business, and whatever other assets you have, they get an equal 1/3. The idea being is they've already helped build up the business. And why should they build up the inheritance for their sibling who's not in the business? That's an approach. Or you can buy life insurance again. So you buy life insurance to give money to the child not in the business, again, trying to even it up to some extent, or some combination. But the point is, you're never going to be able to make it equal, because you're doing the estate planning now at this point in time. And hopefully you live a long life and the business may grow in value, it may shrink in value. And the children in the business are throwing their livelihood, their risk in this business, which may do well and it may not do well in the future. So there are all sorts of dynamics on this. There's no one answer for everybody. The point is, you can't make it equal. You can try rough justice. And that's always my recommendation on that. And one other thing I didn't mention in the outline, but I encourage you to think about, we put in most of our documents an interim clause. What that is that says if someone protests the will or the trust, they risk losing everything. Because the document will say if they protest it, they're out. They lose everything. So they're rolling the dice. They either have to win if they try to dispute the validity of the documents. If they win, so be it. They've disputed it and they're successful. But if they lose their entire inheritance. So it makes it very much of a very risky proposition for someone to protest the document if they're inheriting a substantial amount of assets. Again, if there are any questions, you can type them in or ask them as I go along. Okay, so going to the next page. Okay, now many times, okay, so the children are adults, they're working in the business, they're starting to make noises that they want some shares in the business. Maybe you can give them shares. You can give them voting or non-voting shares. Even, by the way, if you're an S corporation, there are a lot of people out there who think S corporations can't have non-voting shares, but you can have non-voting shares for S corporations. If you have an LLC, you can do the same effective thing, non-voting and voting units. If you're a regular C corporation, of course, you can have voting and non-voting shares. So you can manage it so you can give ownership interest to the kids, because many times, by the time they're 30 and 40 or 50, they may not, hopefully you live a long life. They may not inherit this business until you're 60 years old. They're going to start wanting some shares. So you may have to start giving them some ownership interest, but you may not want to lose control. So you can, in essence, if you wanted to, give away 99% of the business, and the value of the business is non-voting shares, and keep 1% as voting shares. Excuse me one sec. So there is a risk to that. And again, you have to have a shareholders agreement. If you don't have a shareholders agreement, don't give any shares out. But if you're starting to give shares out, you need a shareholders agreement. But there is a change in the legal status once your child becomes a shareholder. While your child is a non-shareholder, they are an at-will employee, as all your employees are, unless you have some special agreement with them. An at-will employee means you could fire them for any reason except the standard, sex, age, religion, national origin, that sort of stuff. You can't fire them for those reasons. But you can, in Ohio, at-will means you can fire someone because you're irritated at them. You don't like it. For whatever reason, you found someone better. Once your child, or anybody for that matter, becomes a shareholder, they're no longer strictly an at-will employee. You have to have a good reason to terminate them. Otherwise, they could possibly bring a lawsuit against you for a breach of fiduciary duty. In your status as the controlling shareholder, you have a fiduciary duty to minority shareholders. You have to be fair. You can't just take out any salary you want any longer. Once they own shares, even if they're non-voting shares, you now have bigger obligations. You have a fiduciary duty to the minority shareholders to treat them fair, including terminating them. So it's a big step when you make someone a shareholder. And by the way, even in a non-family situation, I really tell clients who own businesses, don't just hand out shares willy-nilly. You really need to think it out. If you're going to give shares to, let's say, valued employees to encourage them to stay, just recognize you've increased their power, even though they own minority shares. So now you've gone past that. Let's say you're about to retire, or you're going to retire. You're going to turn over the business to your kids. Who runs the business? If you're not going to run it anymore, that's the biggest decision to make. You have two or more children in the business. How do you decide who the boss of the business is? There's no easy answer to that, by the way. You could have it as a democracy and just say, okay, you guys vote, decide who runs the business, and I'm done. And that'll work if you have many children and you're comfortable with doing that. Many times, the hard thing to do is you appoint a boss. You choose among your children who you think is the best qualified to run the business. That is a very difficult thing to do. It's hard because you're going to 2 or 3 of your children and saying, I think Johnny is the best to run the business. Now, if it happens that Johnny's the oldest, you can kind of, soft soap it a little bit and say, oh, it's because Johnny's the oldest, that's why. But if Johnny's not the oldest, it becomes a problem because the others are going to be a little bit offended by it. But you have to decide what's best for the business and therefore and directly what's best for them. So you need to decide whether you want a democracy or you want to appoint one person. And even then, that may be the person who runs the day-to-day operations of the business. But what about compensation? That's more difficult. You know, if you give one person the right to decide all of the siblings' compensation, you can see the potential issues there. So you need to address that. Or do you have an independent person decide compensation, or you just divide the compensation pro rata? There's no easier answer to any of these questions, but there are questions you need to address when you talk about succession planning. And what if you still need money from the business? You're ready to turn over the business. You've got good kids in the business. They're going to run it well. You're comfortable that they can handle the business. You want to retire, but you need money. So what do? And you could try to stay, if you give away most of your shares, you're going to give away most of your shares and you can't get dividends. You could stay on the business and try to get a salary. It's not entirely clear you could do that if you're down in Florida, while they're up here working, and argue that you get a deductible salary. So many of our clients sell the business. They sell the business to their children. And now the part I hate doing this is I'm going to give an example. So before I give the example, because it's always hard to file a mathematical example, but I'm going to try anyway. Before I do that, any questions, feel free to type them or raise your hand. But now, let's go to the next slide. Now this one I'm going to try to go through slowly because this is a math example. So I'm going to even look at my example. I apologize. So assume you sell your business for $1 million to your kids with a 10-year installment note at 5.5% interest. So over 10 years, they're going to pay you back $1 million plus interest. That gets to be around $300,000. By the way, I'm making broad approximations here. This is not exactly dollar for dollar correct, but I just want to make a simple example. So, you get around $1.3 million. Now, without a defective grantor trust, which I'm going to talk about in a moment, when you sell your business for $1 million, let's say you started it for $1. I know that's an outrageous example, but it's going to make my math easy. So you sell the business for $1 million. You have basically $1 million of capital gains, plus you receive $300,000 of interest. You pay income taxes on all of that. And that ballpark, $300,000 of taxes. Again, it may be a little bit more depending on your tax bracket, but that's a good number to start with. So after taxes, you clear $1 million. However, your children had to come up with that money, that $1.3 million. Now, where do they come up with the money? Well, basically, the business pays for you. The business pays that money so they can buy you out. For the children to get $1.3 million from the business, they're going to have to earn around $1.8 million. So they take $1.8 million of income. They give the IRS around $500,000, probably a little bit more, but $500,000 of taxes. They have $1.3 million left. They pay you $1.3 million, and then you pay taxes on the $1.3 million. In my example I talked about, you pay all those taxes. So, that's the result. For you to get your $1 million, your children have to earn $1.8 million. Not the most tax efficient way to transfer the business. Now, there's something called a defective grantor trust. That used to be mostly used to save federal estate taxes, and it's still a valuable tool to save federal estate taxes. I'm not going to go into the details of it, but it's a very good tool. If you have a federally taxable estate, that means an estate between a husband and wife of over $23 million, it's something to consider because not only does it have an income tax advantage, but it saves federal estate taxes. And again, I can describe that at another time. But I'm using this as an income tax planning tool. So assume the business does the same thing. You sell your shares to an irrevocable trust for the benefit of your children. It's irrevocable, but it's called a defective trust, which means you pay all the income tax on the earnings of the trust. For various technical reasons that I'm not going to get into, when you sell that business to this trust for a piece of paper saying, I owe you $1 million plus $300,000, the trust is signing that note, it's not deemed as a sale. So when you receive that $1 million note payments over 10 years, plus the quote $300,000 in interest, there's no income tax. You receive that $1.3 million free of income tax. I know it's unbelievable, but it's not a risky position. Now, however, because the tax law and this little quirk in the tax law, you're still deemed to be the owner of that business. And by the way, you have to be a pass-through entity on this. I did make that clear. Either an S corporation or an LLC, or this will not work. So even though you've sold the S corporation shares to the grantor trust, for income tax purposes, you continue to pay the income taxes on the earnings of that trust from the S corporation. So assume the trust earned $1.8 million, just like before in my example. You pay income taxes of $1.8 million. So I'm using around a 1/3 income tax bracket. Let's say you give the IRS $600,000 of taxes, you clear $700,000. You're not too happy right now with me because you only got $700,000 before you had cleared $1 million. But your children will not have to pay any taxes on that $1.8 million. So they only have to earn $1.8 million to pay you your money. Excuse me. Yeah, so they end up paying you $1.3 million. Let me take a step back because I didn't do a good job. I assume the business still made the same $1.8 million. They give you $1.3 million. That was the deal. Remember, $1 million of principal, $300,000 of interest. They still have an extra $500,000 in their pockets. They're pretty happy because this deal gives them an extra $500,000. You're not happy because you lost $300,000. But as a family group, you're ahead $200,000. Now, what you really do is you sit down and you massage the numbers so mom and dad get back the way they want it to be at the $1 million. And you're still, as a family, you're ahead $200,000. So it's a great tool. Obviously, that was hard to understand. It's complicated, but it's a great way to transfer the business from the kids, mom and dad, to the kids, reducing the level of income tax if you're going to go the sale route. Now, I know that's a lot to digest, and if you want to try to ask a question on that, feel free. There are other tools that I'm not going to go into today. Grantor retained annuity trust or uni trust, that is self-canceling installment note, an ESOP, really complicated, an ESOP, insurance trust. These are other ways to transfer the business from one generation to the other. Okay? So I'm going to keep on going. Now, how do I make sure the business stays in the family? Well, first of all, remember I mentioned a shareholders agreement, and that's a very effective tool. But another tool that we talk about a lot, we do in planning, by the way, not just for family businesses, we do it just for transfer of family wealth. And that is what we call a bloodline trust. A made-up name, we gave it that name. On your death, the family business goes into a bloodline trust. Whilst in the trust, on your death, these assets go into the trust. These assets are protected from any creditors except the IRS, okay, and the state of Ohio. So if your children get divorced, they can't get these money, the family business, the ex-spouse. If they have creditor problems, creditors can't grab the shares of the company. And on their death, on your child's death, you could put in the document that it goes to your grandchildren, have it held in trust for them or not, depends on the situation. So you can keep it in the family, just keeps going down generation after generation. It's a great way to protect those assets. It's ironclad. When it's in that trust, except as I mentioned, the government, no one can get those assets. You protect it divorce, you protect it against creditors, you keep it protected. It's a great way to pass the business on and keep it in the family. And as I said, you can do that. If you're not going to use this trust, then you definitely need a shareholders agreement if you want to protect the assets and make sure they stay in the family. Okay, let me move on to the next. Whoops, again. There we go. Okay, so another asset that many people have are real estate. Now, it could be real estate that's just apartment buildings, rental units, commercial buildings you invested in. Many times, it's related to the business. In other words, you have this operating business, and you bought a warehouse or a factory, and you own it separately in a separate entity, typically a limited liability company, that leases the facility to the business that you own. Now, if that business is crucial, if that building is crucial to the business, then you might want to limit the ownership to the children who are in the business. If it's not crucial to the business, then maybe you divide that ownership equally among all your children. Because you're going to have to decide issues, issues about rent. So if the business is renting the building and some of the children who own the LLC are in the business and some aren't, you can have a dynamic there. It might cause a problem if people are arguing about what fair rent should be. You also need to decide, if you want to keep this real estate in the family and who runs the real estate. Many of the same issues that I talked about in a family business, but many times real estate, because it's a more passive asset, you don't have to have all the same bells and whistles as you do for a corporation. So I recommend, matter of fact, real estate should never be owned in a corporation. Should never be owned in an S corporation or a C corporation. If you've already done it, it's probably too late to do anything about that now. But if you own real estate, hold it in a limited liability company. You get, first of all, the asset is protected from your creditors. Also, you're protected from the real estate because real estate has its own dangers. You can do estate planning much easier with an LLC because you'll have what's called an operating agreement, which is much like a shareholders agreement. You'll have shares, usually called units or interest in the LLC. And it's hard to give a fractional interest in a deed to somebody, but you can give your children units, shares of this LLC. So if you have a federal estate tax problem, you can start giving them shares of the LLC. And it's much easier because it's just a piece of paper. It's not filing a new deed. It's also, so it makes estate planning easier. Also, it makes succession planning easier because in this operating agreement, you can set forth who runs the property, who makes the decisions, what happens if someone passes away, are their units bought back, what value do you pay for them, how do you pay for them, all the issues that you address when you have a corporation with a shareholders agreement. So you can have all those issues decided in an operating agreement. It's much, much similar in that way to a shareholders agreement. And also, again, the LLC on itself can make sure that only family owns it, that you prohibit non-blood from being the owners of the LLC. So it protects you to some extent from some strangers owning the LLC shares. Okay, so let me continue on. Now, I have a schedule here. I got to tweak this outline a little bit. So let's say you hold multiple pieces of real estate. My outline got a little bit messed up. I apologize. So it should say industrial building under both of those. And then the third one should say a residential property, a rental property. But it fell off, and I apologize. So let's say you own a bunch of real estate and you've got several children and you want to have a way to run these properties on your passing. Many times I set up a holding company. The holding company has an operating agreement that says who's running the properties, who the boss is, maybe it's a democracy again, restrictions on the transferability of ownership. So it's one document that controls all the real estate. But I don't want all the real estate held inside one LLC because then if you have an environmental problem on one property, it brings down all the properties. So I'll set up LLC 1, 2, and 3, and I'll put the separate properties in each LLC and then have the holding company LLC own 100% of LLC 1, 100% of LLC 2, and 3, and so on. There's only one federal income tax return that has to be filed. In Ohio, only one income tax, well, there is no income tax return for the Ohio level. It all shows up in your 1040. But there's only one federal, it's actually a partnership, a 1065 return that's filed. You don't have to file one for each LLC because it's 100% owned by the holding company. So you can manage your properties and have them managed after you pass away among all of them under one holding company. It'll simplify things rather than have a separate LLC with separate owners in each individual one. So to me, that's a great way to handle the properties if you're in that situation where you have multiple properties. Now, you can go crazy on this. So for example, if you have single family homes, I'm not suggesting you have a separate, a single family rental properties or duplexes. I'm not necessarily recommending you have a separate LLC for each one. Maybe you group them, some that are near each other, you have an LLC 1 and LLC 2. So there is some protection in case you have a problem with one or the other. So that covers everything I'm going to talk about today. If you have any questions, I am going to hang around here and take questions. I encourage you to follow our seminars. We're trying to do them every 2 weeks or so on different topics. And if you have any email questions, it should be on the front page of the outline, my email address. This is there. And if you have any questions of me, you want to email me or have a personal planning appointment with me or one of my partners in the firm, feel free to give us a call or email me and we'll do that. And thank you very much for attending. And I'll stay around if anyone has any questions. Thank you.